Good morning, everybody.
But what better way to
I
start your
am
day
Jeff
than
Vastola.
by getting free legal advice?
Here to
This
give you
is
free legal
Vastola
advice.
on the law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your
Good morning,
questions.
Aunt Carol.
877
Hope everything is wonderful in Buffalo.
8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning into the show. I am Jeff Vastola. I'm your host. I've been an attorney in Florida almost 25 years now, and I see that I've got my family up in Buffalo watching this morning. Good morning, Aunt Carol and Uncle Jeff. Nice to see you guys on Facebook Live. If you're listening on the radio and you feel like you're missing out because you're not on Facebook Live, then friend request me, and I will do my best to accept your friend request, and that way on Saturday mornings at 7:30 you can go live on Facebook with me, and you can type in any kind of a question or a good morning, as I just got from my Uncle Jeff, and type in questions of your own as the show proceeds. And if you have tried to friend request me and I haven't accepted your friend request yet, then send me a text and let me know that, or call me. The best number to call me is 833-VASTOLA. That is a toll-free number that forwards to my cell phone 24/7. If I don't answer the phone, just leave me a quick message to say, hey Jeff, my name is blank and I friend requested you. Can you please respond? Like everybody else, I'm sure you get friend requests from people that you don't know, you don't recognize, and I don't always accept everybody. So I realize that it might be somebody who listens on the radio that I've never heard from before, but let me know who you are. And you can become a part of the Facebook, what do we want to call this, listenership. Yes, Don, a long-time listener and not a long time, but a new Facebook watcher, did tell me during the week that he was going to be calling into the show. So good morning, Don. How are you?
Good morning. I had a tooth broke off in July, approximately July 2017, and I had gone to the dentist, which he suggested that the tooth should be removed and he would replace with an implant. And he then told me that I would have to pay in advance that $3,300. And then I said, okay, we'll go ahead with that. And after the completion of the implant and the temporary on top, I had to go back to see him about every week. For the first week, I had to go back and see him, and he checked it and he moved it back and forth with his finger a little, and he said, well, it didn't hold right now, and he said, come back in 2 weeks and I'll do it again. And I had to go 3 times in 6 weeks, and he would move it back and forth. He said it didn't hold, and he said that he would have to remove the other teeth and put in an implant, which he did. And about a couple of years later, the clasp on the implant had clasped the abutment of another tooth had broken, and the implant had cracked slightly in the center. And I had to go and then obtain another implant. Well, I just feel that he didn't do the job right, and I had consulted with 2 other dentists that said that it takes 3 to 6 months for the implant to press in the bone, and it would take other without using it or
Hey Don, let me cut you off, okay? Yeah. Because we're cutting into the show, and I have to actually cut off the show at 7:50 this morning because of my son's soccer game. So I want to thank you again for calling in. Don had contacted me during the week, and we agreed that this would be a good topic for the radio show. So much appreciation from me, Don, for you calling in. Let me address some of the issues, though, that are wrapped up in the issue that you're presenting here. First of all, this advice is only good in the state of Florida, because other states, for example, up in Buffalo, New York, I have no idea what the statute of limitations is for dental malpractice in New York. But down here in Florida, what, Don, you're talking about is potentially a claim of dental malpractice. And again, thank you for not mentioning the name of anybody else. That's very much appreciated. In Florida statute 95.11 regulates what we call the period of limitations, which most people call the statute of limitations, which is the deadline that you have to bring any kind of a given claim. Dental malpractice is akin to medical malpractice, and so it's a 2-year period of limitations, a 2-year deadline, but the clock starts to tick when you knew of the malpractice, the incident that caused you injury, or alternatively, if you don't know, because especially in medical malpractice, you oftentimes don't know that you've been the victim of malpractice until much later on. And so there is a reasonable person standard that's included in the period of limitations, and it's sometimes quite vague and very difficult to pinpoint exactly what the deadline should be, because the reasonable person standard says, well, if you don't know exactly when the malpractice occurred, and those are incidents like, well, you went in for an amputation and they cut off the wrong leg. Okay, you know pretty darn well when the incident occurred if something like that happens. But in a situation like this, where perhaps, and it's not even certain that the dentist did anything wrong in Don's case, and we have to make that clear. But is it when the dentist first did the procedure with the implant, or was it, as Don mentioned, maybe a couple years later when it broke? And he found out that perhaps when it was done originally, it wasn't done right. Don's not expected to know that when the work is done, assuming Don's not a dentist, and I don't think that he is. So that reasonable person standard of the period of limitation says when you knew or should have known through the use of diligent efforts or whatever, some similar language like that, that's when your 2 years would begin to run. So, Don, there is a question as to whether or not you still have time to pursue this potential dental malpractice claim. But what I also wanted to talk to you about, and everybody else that's listening today, is that medical malpractice claims are incredibly difficult in the state of Florida. And that's because there's almost a legal preference to, in a way, protect medical care providers. And you can have your own personal opinion on that. Personally, I think it's a good thing that the medical malpractice statute requires that cases be vetted before a lawyer can take them and run with it. The vast majority of medical malpractice lawyers in the state of Florida are not also physicians. There are some. But even if you happen to find a plaintiff's lawyer who is a physician, there is not one single physician in the world that practices in every different specialty. So even though some lawyer might advertise himself or herself as being, hey, I'm a lawyer and a doctor, that doesn't necessarily mean that that person's going to be qualified to make decisions about whether or not to take a malpractice case. If you've got a cardiologist who went to law school and is now practicing as a lawyer, and Don approaches this person and says, hey, can you take my dental malpractice case? That person, being a cardiologist, is going to do him no good. You still have to follow the mandates of the statute, which is you have to have all of the relevant medical records reviewed by an independent expert, and that independent expert has to be willing to say and sign an affidavit that the potential defendant doctor or dentist, whatever the case may be, who is a doctor, breached the standard of care, and also that breach has caused you some element of damage or injury. You cannot pursue a medical malpractice claim in the state of Florida unless you have that affidavit in hand. That affidavit, assuming that you've checked all the boxes, dotted all your I's, crossed all your T's, then allows you to proceed with what's called a notice of intent. You still can't go to the courthouse yet. You still can't go file a lawsuit. You have to go through the process of what's called a notice of intent to initiate a claim of medical negligence. That process is a 90-day process where the defendant is then given 90 days to investigate the claim and decide how the doctor wants to respond to the claim. It could also be a hospital, it could also be a surgery center, whatever the defendant is. It could also be a dentist. So Don, I appreciate you calling in. As I mentioned to you on the phone, there's no way for me to say yes, no, black or white, you have a case, you don't. But based on the conversation, let's talk again on Monday. I think I learned a little bit more about the incident this morning than what I had known previously during the week, in that it seems as though maybe some injuries didn't become known until recently. So we'll talk again on Monday if that's okay with you, Don.
Did you want me to call you Monday?
Yeah, call me on Monday, and we'll talk again, okay?
Good.
All right. And that number to call, this is
Okay,
for
thanks
Don.
very much.
Thank you, Don. Appreciate it. The number to call is 833-VASTOLA. That's 833-827-8652. That's the number that forwards to my cell phone 24/7. Now, if you want to call into the radio, I was just going to say, if you want to call into the show, I was going to give the number. Did you say, Sharina, the name is Jeff?
Yes.
Okay. Let's talk to Jeff in Juno Beach. Good morning, Jeff.
Hey, good morning. Thanks for taking my call.
Sure. What can I do for you?
I'm not sure if this is... I'm sorry?
I said, what can I do for you?
I have a question. It has to do more with probate. My wife is a self-employed accountant. She had a client who owed her several $1,000s. The client passed away. The son has the estate. So her and another co-partner of hers, an accountant, had given invoices to them, basically saying, he still owed $1,000 on this account, $4,000 on this account. We received a letter from, I guess, the attorney who's handling the probate for the deceased. The fund filed a claim rejecting the claim. So the question is, what's the best way to proceed? It really doesn't say in the letter, it states the statute, but it really doesn't state what we need to do. I'm assuming do we respond back to that attorney, or do we have to file something in the court to basically, so she can show the documentation and her proof that yes, she did all this work and is owed the money?
Okay. Well, I understand the question, Jeff. You have you have stumped the chump, because I don't handle probate stuff, but I'm not going to punt. What I'm going to do is I'm going to do the research on your question and be listening in. Oh boy, next Saturday I'm actually going to be in Colorado on vacation, so I doubt that I'm going to be live next Saturday. And if that is the case, then I'll do the show on your topic in 2 weeks from now. But what I want to do is I want to get you an answer faster than that. So why don't you call me Monday or Tuesday, and you and I will talk again about what I have found. Okay?
Okay.
And I'm going to do the research to give you what I think is a decent answer to the question, but I'm also probably going to refer you to a probate attorney, and that way you can pursue that if you think it's worthwhile.
Yeah, we're just looking to know basically what process we need to follow to kind of give our side of the story.
Okay. All right, good. Yep, I'll let you know. Just give me a buzz. That number, 833-VASTOLA. Call me Monday or Tuesday, okay?
Okay, thank you.
All right, thanks for calling in. All right, real quick. I had a phone call last week from Glenn, and Glenn tried very hard to convince me that the law in Florida, when he received a package from UPS that did not belong to him, he opened it, found out that it was a cell phone. He wanted the law to be the finders, keepers, losers, weepers type of approach. Try as I might, Glenn, unfortunately I did not find anything to suggest that you can keep that phone. I wanted to follow up with you on this issue, Glenn, because I told you I would, and also because I feel it's important for anybody else that might be watching. Anecdotally, I did find an article on the internet about a person that apparently did the same thing, received a delivery from UPS that did not belong to him, kept it, refused to give it back, and was then arrested. It does amount to theft. So if they can prove, of course, that you are the one that kept the goods and refused to give them back. If they don't belong to you, they don't belong to you. That's morally the position that you should be taking. And also legally, I would imagine in other states, but in Florida, if you keep something that doesn't belong to you, you can wind up in both sides of the courthouse. Okay, what I mean is, in any given time, but let's say pre-COVID now, there were two sides to the courthouse operating every day. There was the criminal side of the courthouse, which dealt with, is somebody going to go to jail or not? And then there's the civil side of the courthouse, which is dealing with, okay, is somebody going to be awarded money for an injury, or is the judge going to make decisions about who owns a certain piece of property or real estate? That's the civil side of the courthouse. You're not dealing with a jail term. But in a situation like this, you could literally be dealing with both sides of the courthouse, because first of all, you're keeping something that doesn't belong to you, which is theft. And Florida has what's called the civil theft statute, which says that a person, this is Florida statute 772.11, says that if you keep something that doesn't belong to you, and if you are asked to give it back and you do not, then you can have this lawsuit filed against you for what's called treble damages. Now, in a case like this, the value of a cell phone these days, even the most expensive cell phones are $2,000 for a flip phone, which is a lot of money for a phone. But in the grand scheme of things, it's not a lot of money, especially if it's tripled. Treble damages means 3 times the amount of the stolen item. So if you have a phone worth $1,000, treble damages say, okay, well, you could owe as much as $3,000 if you keep the phone. However, the more important aspect of the statute is that it also allows for prevailing attorney's fees. So if UPS were to hire some blue chip firm to sue you for civil theft because you refuse to return this phone, you may say, oh, big deal. You know, they have to send me a letter, and that's set forth in the statute. There's what's called a condition precedent to filing the lawsuit. The person who has been aggrieved would send a letter saying, you've got 30 days to return my item. If you don't do that, then they have the green light to file the lawsuit for civil theft, seeking treble damages, costs, and prevailing parties' attorney's fees. It's not unusual in a situation like this where the amount at issue, which would be the amount of the phone, or perhaps even 3 times the amount of the phone, is far less than the amount of attorney's fees that accrue, even sometimes before the lawsuit is ever filed. And so the moment the lawsuit's filed, you may contact the other side and say, oh, you know what, I changed my mind, I'm going to give the phone back. And they say, well, guess what, too bad. My lawyers have already spent $10,000 on this issue, and now you have to pay us the $3,000 for the phone, and you have to pay us $10,000 for my attorney's fees. And if you refuse to do that, the clock is just going to keep ticking, and that bill is just going to get more and more and more and more. That's my fear, Glenn, is that if you keep the phone, things are just going to go bad for you. You know the phone doesn't belong to you. As I mentioned, Florida is not a finders, keepers, losers, weepers state. I don't think there is a state that applies that doctrine. But if you have any follow-up questions, Glenn, then obviously call me. Listen to the show, type in a question on Facebook Live. Good morning, my cousin Debbie. Nice to see you.
Steve from West Palm Beach.
Who do we have?
Steve from West Palm.
All right. Unfortunately, I'm going to have to hold off on Steve. Ordinarily, this is a 30-minute show. I do apologize. I have to cut out 10 minutes early, and that's about right now. It's about 7:50 because we have to get down to Parkland for my son's soccer game. So my apologies. Sharina, please tell Steve to call 833-VASTOLA, and I will take his phone call offline, okay? Thank you, everyone, for tuning in. Thank you, Sharina. Sorry to bow out early on you, but I know you're prepped. And everyone have a great week. If anybody needs anything in the way of legal advice, please call me, 833-VASTOLA. And I'm also a big proponent now. If anybody needs a prayer for any reason, please reach out to me, because I received a lot of benefit from folks when I needed it, and I know personally how well it works. So I'm out. Have a great week.